Hey everyone, welcome to the Cathleen Scott podcast. We're in our new studio and excited to be coming to you. We did a case study on a case involving the EEOC, the Equal Opportunity Commission, versus the trustees of the University of Pennsylvania. You might remember that this is that case where Commissioner Lucas herself personally signed an EEOC charge to open up an investigation against the University of Pennsylvania, and as part of that investigation issued a subpoena to the university asking them to produce employees who belong to various religious organizations. That subpoena was now, the University of Pennsylvania did not comply with that subpoena, and so the EEOC filed a lawsuit seeking to enforce them. The legal terminology is they filed what's called an order to show cause, why the University of Pennsylvania shouldn't be held in contempt of court or something similar because of their failure to comply. And so a lot of individual organizations weighed in on whether or not the EEOC has the power and the jurisdictional depth to execute a subpoena seeking these types of things, particularly in the absence of an individual who was named in the charge of discrimination. And so I have an update for you on that case. When we left off, the court was considering whether or not to grant the order to show cause or whether or not to force the University of Pennsylvania to produce those documents that were sought. A couple of things happened since then. One, the EEOC did more narrowly tailor its subpoena requests. So it's focused now on employees, their particular records. And the another thing that happened is the court heard oral argument and it ruled on March 31st, 2026, the court did in fact order the University of Pennsylvania to produce all those documents that were sought after in the subpoena. And so there were 7 main arguments that the University of Pennsylvania made. Each one of them was dismissed by the court. They were considered. So first, the University of Pennsylvania challenged the validity of the actual charge of discrimination. You might remember from the initial podcast show that I was saying how unusual it was for the EEOC itself to be a charging party, essentially. Normally, there's an individual victim and a former employee who's been fired or someone who feels like they're in a hostile work environment. And they file a charge, and then the EEOC does an investigation. In this case, the commissioner herself, Andrea Lucas, a former Gibson Dunn labor and employment defense attorney, filed the charge herself, targeting. And she did it largely based on information that was found in the public database, including testimony from the former University of Pennsylvania's dean, who later resigned. So first question was the charge valid? The court said yes, the charge did provide a, quote, fair notice, and that's all that was required. And it was okay that it incorporated public sentiment, which included anti-Semitic threats and slurs. So that was thrown out. Second question is whether it was relevant to seek information from Jewish-related organizations on campus, including employees' involvement in this educational environment. And the court said, yeah, the relevant standard is so low that at this stage, it's reasonably likely to have something related to the actual allegations in the case. So the court overruled the objection based on relevance. The next question was whether the subpoena presented an undue burden. University of Pennsylvania outlined why this would be a very onerous task to notify all their employees, to get volunteer information and to compile this information. They don't actually keep track of who belongs into which Jewish organization. And the court also rejected that. They said the law gives the EEOC, not the employer, discretion on how to investigate. And so this was sort of extraordinary to me as someone who practices in this space. They basically said that the University of Pennsylvania did not provide any metrics. They didn't say how many hours it was going to take for them to compile this information, and therefore they failed to meet the burden to show it was an undue burden. But it also said that the law gives the EEOC, not the employer, the right to decide and the discretion to decide how to conduct their investigation. So it's almost as if they said, so sorry, employer, your objections don't matter. We're the EEOC. We're going to investigate how we seem fit. And another extraordinary, so they overruled the objection on that basis. The sixth one was privacy rights. The university objected that this is highly personal information, that it should not be produced. It would violate substantial due process to require the university to produce this information and in their rights of privacy. And the court said, no. Contact information and the events that employees attend on campus are not highly personal. And so the compilation of that data is not intimate facts that are subject to privacy protection. That struck me as odd. And then the court also said any privacy concerns there might be are protected under Title VII strict confidentiality penalties. which I take personal issue with, because whether or not a statute protects privacy is really a separate question from whether it's appropriate for individuals to have information released without going through due process procedures. So that one was kind of interesting as well. The next one, the university made a First Amendment objection, basically saying compelling the disclosure of information of employees who have decided to be part of a group that violates the First Amendment rights to assembly, and that should not be compiled and produced. And the court reject that one wholesale and said it no longer, and in part because the EEOC did limit their subpoena and said the government's interest in investigating discrimination outweighs any potential chilling effect that it may have. And then also the EEOC was no longer seeking specific affiliations. Like in the first request, they were saying, identify who's a Zionist or an anti-Zionist, and that was amended. So the court kind of was in good ground to reject that one. Then there was a question of whether there's academic freedom or religious freedom issues that were raised by requiring the university to compile this information. In other words, does that have a chilling effect on academic freedom or religious freedom to know that if you go to a religious group and you're an employee on campus, that information could be produced? And what the court's response to that was that no, academic freedom is only for teachers and what is taught. It doesn't provide any, and it used this language, special privilege to withhold information that is relevant to discrimination. So let that sit in for a minute. If you're an employee of the university or a student of the university, your academic freedom is nothing. It's only the teachers who have it. The court, rejected that, as well as religious freedom argument, saying that here the EEOC has a right to investigate. It really was somewhat unfettered. So that's pretty extraordinary as you think about where this case is going to go. So the deadline to produce the documents was in May, but just yesterday, actually this morning, April 14th, the University of Pennsylvania filed an appeal and a motion to stay, and that will go to the Third Circuit. That's the federal appellate district that's there. And of course, I will continue to monitor how this shakes out on the appellate level. The EEOC, has now what has been determined to be a valid subpoena, and now it has to rely on the Third Circuit's opinion as to whether or not the production for that information can be stayed or not. So more to come on this. I'm Cathleen Scott, and you've been listening to the Cathleen Scott podcast. If you like what you heard, please feel free to subscribe and post your comments. We look forward to having them and to addressing them. We'll see you soon on the next Cathleen Scott podcast episode.